For our final panel this afternoon, we have appearing as individuals Paul Thomas, Professor Emeritus with the University of Manitoba, and Nelson Wiseman, an Associate Professor with the Department of Political Studies with the University of Toronto. Welcome, gentlemen. Thank you for being here. And Professor Thomas, I gather you have the lead with opening statements, so please proceed.
Yes, you're actually listening to two Winnipeggers today because Nelson and I are old friends from the north end of Winnipeg, so you're getting particular flavor here today. So thank you very much for the privilege to appear before this committee. Earlier I submitted a 36-page brief on Bill C-23 to the Procedure and House Affairs Committee of the House of Commons, and I believe that document has been circulated to committee members. I understand also that you may have been provided with my commentary on current debates on the sensitive issue of voter identification. Those debates have been taking place in the UK. Debates over C-23 have focused mainly on a few controversial features like the mandate of Elections Canada and the future of vouching. It would be unfortunate if amendments were made on a couple of contentious matters and other problematic features went unexamined and unchanged. Tonight I will simply list, without much elaboration, a dozen areas of concern about the bill as presently worded. The listing is not in any particular order of importance, although I have placed the more high-profile issues toward the end of my remarks. So this is a dozen recommendations. Number one, add a requirement that all registered political parties participate in the development of a code of conduct indicating their acceptance of certain fundamental principles and values of fair and free elections, and that party leaders, candidates, paid staff, and all volunteers agree to uphold such a code. Second, add a provision extending the application of Canada's privacy laws to registered political parties. Number three, drop the provision of the bill that allows the winning party in the previous election to recommend the name of the central poll supervisor and the provision that allows district party associations to recommend the names of deputy returning officers, poll clerks, and registration officers. These provisions have the potential to give rise to actual, perceived, or potential partisan bias in election administration. Number four, retain the useful provision that authorizes Elections Canada to issue guidance and interpretation notes, but add a requirement that the agency develop and make public the criteria and procedures that will govern their use. Number five, delete the provision that removes from the ceiling on election expenses the cost of fundraising by electronic means where such communications are directed to past donors who have contributed $20 or more. The distinction between fundraising and campaigning does not hold up well in the real world, and the provision is unenforceable by Elections Canada. Number six, on the issue of deceptive communications with voters, so-called robocalls, increase the time period for the retention of records, including recordings and scripts, by telephone service providers from 1 year to 5 years in order to allow time for the completion of investigations. Number seven, amend the bill to provide the Commissioner of Elections with the power to compel testimony when he/she has convinced the judge that the person to be examined has information relevant to an ongoing investigation. Number eight, drop the provision that relocates the position of the Commissioner of Canada Elections from within the administrative framework of Elections Canada and places it under the Director of Public Prosecutions situated within the Justice Department. Number nine, drop the provision that prevents any professional administrator who has worked for Elections Canada from becoming Commissioner, and change the term of the appointment of Commissioner from 7 years to 10 years to ensure that individual will oversee 2 election cycles. 10, reinforce the core task of Elections Canada by passing Section 18 in the bill, but also add a parallel provision that recognizes the right of the agency to study, report, and comment on the conditions within the domain of electoral democracy. Number 11, include a requirement for consultation with the chief electoral officers before future changes to the Canada Elections Act are introduced in Parliament. Number 12, drop the proposal to eliminate the use of voter information cards and vouching, find a more appropriate method for balancing the constitutional right of eligible Canadians to vote with the very remote risk of voter fraud, and I have some alternative suggestions on that. Just to wind up, changes to the Canada Elections Act should be based on widespread consultation and as much consensus as possible. Changes should not be passed hastily and unilaterally, leading to real or perceived political advantages for the governing party. Nor should the changes place the interests or the convenience of all political parties ahead of the voting rights of all Canadians. In closing, I should indicate that I'm a member of Elections Canada Advisory Board, and in that capacity I've been paid for 2 days of work at the inaugural meeting of that body. Also, in the interest of full disclosure, I should inform the committee that during the year 2013-2014, I was the co-investigator in partnership with Mr. Lorne Gibson, the former CEO of Elections Alberta, for a study commissioned by Elections Canada. Briefly, in that study, we were examining the relationships of independence and accountability for national election bodies in 5 countries compared to Canada, including their roles, mandate, scope of their authority, and the way they reported to governments and to Parliament. That study is undergoing translation and will be published in the future. I was paid $18,000 for that. Part of that amount included expenses. I just wanted that on the record so I wouldn't be accused of hiding something about my connections with Elections Canada. Thank you very much, Mr. Chairman.
Thank you. And Council just pointed out to me that in recommendation number 3, this is already in the Act, except it's the candidates who provide the names, and this was actually a request by the Chief Electoral Officer.
Right, yeah, the second part of that, the district local supervisors,
Yeah.
right, yes.
Yeah.
Yeah, I mean, in principle, I would favor merit-based appointments across the board, but I realize there's a history going back some time.
Okay.
Thank you.